It's a huge industry. Medical malpractice litigation is a ginormous industry. And now private equity has gotten involved, right? There are third-party litigation investors because this is big, big money these days. They don't invest in the defense, right? They only invest on the plaintiff side, right? So there's investors in it. This is about this is about them recouping their investment. This is about money. This is about the plaintiff's attorney taking, usually 40 to 50% off the top, plus expenses, plus whatever they owe their investors. And the plaintiff themselves is going to get like some tiny percentage of whatever it is that they walk away with.
Hi, everybody. Welcome to Be Empowered, the podcast. This is a podcast where we dive into the realities of healthcare and entrepreneurship. We offer our opinion, unfiltered, unapologetic, and always with a dose of empowerment. We're here to amplify voices, yours and ours, challenge the status quo, and explore what it truly means to thrive. So let's get into it. I'm Dr. Santoshi Golakota.
And I'm Dr. Shalom Mokbel.
And today we have Dr. Gita Pensa. She's an emergency physician, an educator, and a nationally recognized voice at the intersection of medicine, law, and physician advocacy. She's the creator and host of the Doctors and Litigation, the L Word podcast, where she explores the reality of medical malpractice, legal risk, and how litigation impacts physicians, both professionally and personally. Through her work, Dr. Pensa has helped demystify the legal system for clinicians and has created an important platform for conversations about malpractice, accountability, and the emotional toll of litigation. So, Gita, thank you so much for joining us today in the podcast. We're so excited to have you and also very excited to talk about this subject because I think I don't want to say it's taboo, but a lot of physicians are scared of it. And I think hopefully we all learn a lot from this conversation we're having with you. So to start, do you mind telling us a little bit about your journey in medicine and what initially sparked your interest to create the L Word podcast?
Sure. So I graduated from med school a long time ago now. So in 1997. And I didn't learn anything about litigation in school. I did my residency down in Washington, D.C. I didn't learn anything about litigation in residency. And then I took a job up in Rhode Island in a community hospital. I was a nocturnist. And I was about 5 years out of residency, and I saw a patient who had a very confusing presentation. Actually, it would really interest you if you ever want to get into the medicine of it, because it was kind of a fascinating case looking back at it retrospectively. But at the time, I was just like, this is weird. I puzzled over it. The record showed me doing her exam 5 different times. I documented a very good neuro exam, and I did a head CT. I woke up somebody, I consulted, I sent her home with that person's blessing. They were going to see her in the office at 9. And I discharged her at 6:30. And then she went home and she had a massive cerebellar stroke. And so she was 31 years old. She was an engineer. And if you know anything about malpractice, what that means is, well, I live in a state that has no caps on anything. It's very, excuse me, very plaintiff friendly state. And this is a young person who was an engineer, and the damages were significant. So when you add those things up, someone's going to come looking for a lot of money in the state. And so I wound up as the defendant in a case that wound up lasting 12 years, and I went to trial twice, first in 2011, then 2018. And between the first trial where I won, and then there was an appeal, and then the verdict got overturned, and then I wound up going back to trial a second time. Between that verdict being overturned and going back to trial a second time, I realized I've been suffering for a really long time from litigation stress. I didn't know that was the name of it, but I knew I had not been well for quite some time. And having to go back again was sort of the impetus for like just realizing I was in a lot of trouble and I really needed to learn how to do things better for my own self and my own life. It had been like a decade I'd lost to this thing. And in the process, I learned a lot about how to dig yourself out of a real deep hole in medicine, and just in terms of burnout and anxiety and depression and perfectionism and shame and all that stuff. And at the same time, what does it mean to be good at being a defendant as a doctor in medicine? Like, is that even something that you're allowed to want to do? And so I learned a lot about tort law and legal performance, and essentially got myself an education. And so by the time I went to trial the second time, I was a highly confident witness. I was feeling really good about myself. I was feeling really good about medicine and the practice of medicine. I invited my residents to come to trial to watch me testify. I invited, my friends were there. Like people came to support me. I was not ashamed of this at all. I testified really well. It went in my favor, and then I realized, I learned a lot. And I very much wanted to figure out how to share that knowledge to make an impact in medicine. And so the podcast that you mentioned, thank you, Doctors and Litigation, the L Word, was the first iteration of that. And really, I still practice half time, but like really my whole like ethos now is it's just geared towards how do I make an impact here? How do I change this culture? How do I change the system?
Yeah, I agree with you that it's a huge gap that we don't understand or even learn about during residency. Many
Mhm.
physicians, in fact, fear litigation, but don't fully understand, how the legal system or the legal process actually works. Can you walk us through what typically happens, when a physician gets sued?
Okay. Well, let's back it up 2 steps to something bad happened, right? And you may not know that the thing happened. Like in my case, I didn't know what happened to this person because she went to a tertiary care center after that. And then I just got named. So if you're in a field, you may not remember the event. Something shows up before the end of statute of limitations. But after that adverse event, it's usually some kind of disconnect. The patient had a certain expectation, or something bad really did happen, or maybe there was an error or a misdiagnosis or something, but somehow there's a mismatch between what you think and what the patient believes. And they'll often be told, it's not easy to get answers from a healthcare system, to be honest. So maybe they don't get FaceTime with you. But they'll go to an attorney and see, do I have a case? And that attorney, a plaintiff's attorney, is going to hear you out, and then they think that there's a potential that they'll make money from it, right? And they're doing the math that I just talked about. Like, how bad are the damages? Is this a young person? Like, would this bring in money? They won't take in everything, and so they think like, okay, well, this maybe is a reasonable case that I might be able to make some money on. They contact an expert to see like, hey, does this thing have legs? And maybe an expert says like, sure, I'll testify for you. And they are actually doing all this sort of background work, and maybe they've already requested the chart. They've been kind of like thinking about it, and all they have to do is to file it before your state's statute of limitations runs out for that particular whatever it is. And so if you're in peds or OB, like that could be a really long time. That could be till 18 or the age of majority. But for a lot of cases, depending on your states, 2 years, 3 years, something like that. Then you are in some states given something called notice of intent. You might get it's like a shot across the bow, like something's gonna happen. We intend to sue you, but we're not suing you yet. But that's your official entry into the system. We don't have that in our state, but the first notice I got was just here's your notice, you've been served. So that's your official entry into litigation. There may have been, some other negotiations pre-lawsuit. Sometimes people will try to settle things out of court. They may try to reach out to you, and you through your insurance may be able to do something out of court. But actual lawsuit, once it's filed in court, you're off to the races. So then you enter something called the discovery phase. And this is where each side is trying to get information from the other side, because under constitutional law, this is civil litigation. We're not talking about criminal right now. Most malpractice cases are civil litigation. Each side has the right to know the other side's evidence and their arguments. And you have the right to depose the witnesses that are going to be produced on each side. So at first there is, we want records, we want this, we want that, we want the plaintiff's medical records. So the plaintiff is the person who has the complaint. That's the person who's suing you. And then you're the defendant. And you as the defense side wants what the plaintiff's got. The plaintiffs want what the defense has. Everybody puts up all sorts of barriers to giving everybody what they want. Then as part of the discovery process, the depositions will start. And sometimes there is these other things, depending on your state, questions called interrogatories that are written questions that you'll have to sign and attest to. And just there's a lot of other intermediary steps. Some places have tribunals to see if a case should proceed forward or not. They're usually pretty easy to get by from the plaintiff side. So whether or not they have teeth, it's hard to say. Not every state has those. Now it's going to be your time for deposition. All of the witnesses in a case are going to get deposed. So you will be deposed as really what's called a fact witness, like as a witness to what the events were, but you will, of course, have medical opinions about things. So there's going to be a little blurring. They're also going to depose all the experts that are involved in a case. So experts are there to give their opinion as to whether or not this person met standard of care. There'll be experts on both sides. So basically, through this process, everybody gets to see like what's the strength of my case. Is this a case that any given side would want to settle? Is this a case that the defense is going to want to really defend and not pay any money out, and then they'll probably push for trial? And you would love for all of these decisions to be made on the basis of your medicine alone, and it is very much not the case. It's really just about which side has a more convincing story. Um, the plaintiff's attorney is going to craft a theory of negligence that can change over time. They can get different experts. They can get, there's all sorts of ways. You're sort of stuck with your medical facts. They can create a whole story around why it is that you were negligent, and all they have to be able to do is sell it to a lay audience that doesn't understand medicine. And so our role is to figure out how to explain the medical facts well and what is reasonable and why, and to represent ourselves as witnesses. And we should be good at being witnesses.
So we've all been in situations where the case might have been complex or difficult, or you come after a colleague. I mean, in emergency room, you guys have a lot of turnover. In neurology as well, like we take turns, we do different shifts. You come after a colleague and you find that something had been missed or was documented very poorly. So now you're concerned that something bad has happened. I mean, let's say you catch it and you make changes, whatever, but how do you make sure that you are protecting yourself in those types of situations?
Okay. So documentation it's very important. It's often not enough to keep you out of a case, right? But it will help you very much when you're in a case. So rock solid, I mean, that might be overstating it. Sometimes if you have like super rock solid documentation and that plaintiff's expert sends it out to somebody for review, and they get an ethical expert and they look at the documentation and say like, look, man, I think that this person probably did everything right. They may shop around until they find an expert that will say just about anything, but there are some good experts out there who would say like, look, based on this documentation, I think everything was medically reasonable. So you really should, when you document, you should, especially when you're, you won't always know what case is the one that's going to come back and get you. So we always want to document as thoroughly as we can or thoughtfully as we can. It doesn't have to be a book, right? But just to document thoughtfully. And really a dispassionate telling of the events. You don't know what that person before you was doing or thinking or what the patient looked like at the time. And so rather than documenting in a way that throws somebody else under the bus, hoping that like the blame will fall over there instead of with me. First of all, the likelihood is that you'll both be in it. But it's really not helpful to anybody, right? So you just start where you picked up and talk about what you knew before, and then you document things as they are, and then feel like, this is what I think the next move is, and that's it. It's just basically a dispassionate telling of the events. Now, if you feel like there's something you have to disclose to the patient or tell the patient, again, you are going to start with like, I am here now, and this is what I know, and this is what I think we should do from here, right? It's really common in medicine especially because we all have this hindsight bias, and we are very, very critical of each other's, we're critical of our own care, and we're taught in M&M to be hypercritical of other people's care. And the fear that we have of getting dragged into something when we feel like, wait, this isn't our fault, sometimes leads us to do things that are unwise. And really trying to like blame somebody else is usually unwise, right? The best thing you can do in terms of documentation is to document thoughtfully about what is happening now, what you feel like should be done from this point out. You have a frank discussion with the patient, and they may have questions for you, and you answer them as diplomatically as you can, and as neutrally as possible, and then you move forward from there, right? Because it's important for patients to understand where they are. I have seen many, many, many cases where the neurologist blames the ER blames the doc that sent the person in. It becomes what we call a circular firing squad, when in reality everybody is trying their best with the information that they have at the time, and nobody sets out to be negligent, and you don't know what was happening in their shoes at the time. So you document your side of things, where you are now, what your understanding was up to this point, very neutrally, and then you keep going forward. Now, if you want to have a conversation with that person, please do that. Please don't have your, like, don't hash things out in the chart. Like, call the person and be like, hey, like, can I talk to you about XYZ, and hear what they thought, or let them know this thing happened, right? This is important that we teach each other, and that we learn from each other, and that we inform each other. But the chart's not the place to hash that out. I see that all the time, and it hurts all parties involved, including you.
In those states that they send an intent to sue, what happens from intent to sue to the actual lawsuit?
There is often some attempt to try to settle this thing out of court. Or it's just like they're required to do it, and then after this period they're going to do it. Maybe that they, they're just continuing to, like, gather their stuff, and they know they're going to file it. But there is, and again, it doesn't happen in every state. It's just basically we're putting you on notice, like, this thing's going to happen. We're starting our processes, et cetera, et cetera. And it's just a requirement in some states. And so whether or not anything really happens between the NOI and the actual filing of the lawsuit. But if you have the notice and you feel like on the hospital side or on the defense side, like, we, we'd really like to see if we could avoid this, then there might be some sort of discussions around that.
Once you've been named in a suit or served an intent, how does that affect your current employment or future employment options? Like, do you have to declare that that's what's going on?
Usually, but really only if it's a good idea to tell your employer, like, that this is happening. If let's say you worked somewhere else, right? And the lawsuit is stemming from your work at that institution. And now you've moved somewhere else, right? And now you're working in a new group. Typically, what would happen is you have coverage, hopefully, from that institution for a certain number of years for things that happened, hopefully up to the statute of limitations for things that happened while you were working at that institution. So that insurance is probably going to cover the defense costs for whatever is happening, whatever lawsuit is coming out of it. You probably should tell your employer, like, just FYI, this thing is happening. You may not be required to until you have to reapply for privileges. So if you're applying for privileges, either at, privileges at your hospital or your state medical license, you will be asked about any recent ongoing litigation or settlements. And sometimes they're within the past 5 years, sometimes they're forever. You have to look at the wording of what you're being asked. But yeah, you'll probably have to disclose that this thing is going on, and it's being adjudicated, or it's in the processes of litigation. And that in and of itself is like, that's a neutral fact. This thing is happening. It doesn't say that you did anything wrong. It doesn't make you bad. It doesn't make you unhireable. It's just that I have this thing going on, and they will usually want you to explain in a few sentences, like, what it is. You can work with your attorney to get a nice synopsis that you can put on there. And it doesn't have to be that this agonizes you. It could just be like, here's my boilerplate answer. It goes in that spot when I apply. And then you don't think about it anymore. That's hard for a lot of people. But yes, then if you have a settlement or a loss at trial, you will have to disclose that as well. And again, you'll have an opportunity to talk about what that was about.
That's a good segue to the emotional and psychological impact that litigation can have on physicians. Can you talk about those from your experience, from what you hear?
Again, we're all different people. We're all human beings with our own lived experiences and the way that we respond to various unfavorable stimuli, right? But in general, for a physician who is naive to the process, who doesn't really understand it, you haven't had any modeling of it. You haven't watched anyone really go through it, which is kind of how we learn in medicine. You role model yourself after someone that you thought was good at what you want to do, and that's how you deal with things. That's how you talk to patients. That's how you adopt their work ethic. Like, that's, you think, like, what would this doctor do when I'm faced with the situation? That's how you learn to be good at your thing, right? But what you probably never saw was that attending going through litigation or a board complaint or anything like that, even though it very well could have happened. And so we're left with this, the main emotional impact of it is shame. Like, you want to hide. You don't want anyone to know. Whenever something's happening to you, you don't want anyone to know about it. That's shame is driving the bus. So that's how you don't want anyone to know this is happening. It could have implications for me. I'm also really embarrassed by the fact that it's happening, and people may have thoughts about that. And what if all these other people know? Like, that's shame driving the bus. When shame drives the bus, isolation is a problem. We also tend to get preoccupied with it in our own heads, right? There's a lot of rumination, and we don't understand the process, so there's a lot of catastrophization and a lot of what ifs, and the anxiety, right? So whenever like the what ifs start, that's your anxiety talking. And the thing about worry, when you don't know anything about what the possibilities are about the outcome, is that, I mean, it takes up a ton of real estate, right? It makes itself feel entirely necessary that you think and you worry. It will affect how you sleep. But that's like the first thing I hear from everybody is, I can't sleep. I can't sleep. I just keep replaying these things in my head, or my fears in my head. When you don't sleep, what happens at work, right? That doesn't feel as good either, right? What happens to every ability to cope emotionally gets thrown out the window when you're not sleeping. And so it sets up a cycle for many people of anxiety, depression, withdrawal, isolation. Sometimes we may turn to substances to try to help us sleep, or it may be substances to help us cope. And that, this is a process that lasts a long time. So that can be obviously very problematic. We have, physical symptoms of chronic stress, whether that's, I've known doctors to have MIs or going to AFib. I know stomach ulcers. It was my stomach. I was on I don't know how many different meds for my stomach, because my stomach was a mess. And interpersonal relationships will tend to suffer because the person wants to isolate and withdraw and not talk about this thing that is taking up all the space in their head. Loss of enjoyment in regular activities. You don't want to go hang out with your friends. You don't feel like it, right? There's no levity in your life anymore. And if you have a spiritual or existential life, this can really put a crimp in that too. So really, in serious litigation stress, every single facet of your life is affected by this. Now, when, in addition to the litigation part of it, let's say that something really bad happened and you feel at least partially responsible. That's hard, right? Because not only are you experiencing your own grief and your own guilt about the event, there's the feeling of litigation really sort of bringing it all to the forefront and thinking like, how am I going to defend this? And there's also this feeling of your role now is to suffer, that you deserve to suffer because something bad happened and perhaps you are responsible. And so feeling happiness or enjoying your life does not seem like that's an option on the table, right? And so I actually just, I'm working with a pediatrician, and one of her patients died, and they were almost 3 years old, and I don't think she could have done anything differently, but this thing happened, and she has a 3-year-old. Like, this is so whenever she thinks about, when she looks at her 3-year-old, she thinks about this other 3-year-old. And how do you enjoy your relationship with your 3-year-old when you are just completely consumed by your grief about another 3-year-old that you felt responsible for that died? It's hard. It's really hard. And so, yeah, I think just this understanding that all the people in it are experiencing pain, right? This doesn't negate the grief of the parents of that 3-year-old at all, right? This is not a zero-sum game. But I think that it's important to recognize that there's pain usually on all sides when these events happen. It's very easy to try. I mean, I'll villainize the plaintiff's attorney. That's fine. But it's easy to try to villainize the patient, or to, just to make there's got to be someone to blame. Like, they're certainly villainizing us. And it may not even be them. It may be the attorney really largely villainizing us. But there is so much pain in all sides. But it just tends to sort of fill us up with pain when it's a really serious thing. Now, even frivolous lawsuits will bring out a lot of anxiety in people, because just understanding, they don't understand the system. It may make them mad, may resent the time it takes to defend a case like that. There's all sorts of emotions that people go through, and that anger will eat people up sometimes and ruin their relationship with their patients and steal the enjoyment from their work. There's a lot of ways that this can affect us, but it does affect us.
Absolutely. And I think the fact that we don't really talk about it or see it demonstrated in front of us also, because it's taboo. We just
Right.
don't talk about that. So I think when it is happening to you, it's extra scary because you don't know how to navigate it, or how to navigate your well-being and your feelings while you're going through it. From your perspective, what are some common misconceptions that physicians have about malpractice lawsuits, if any?
So many.
That they're probably short, right? Because
They're-
it sounds
yeah,
like
I
yours
mean-
went on like forever.
Yeah, I mean, I think there's this feeling of, I didn't do anything wrong, so I'm going to get dropped pretty soon. It doesn't necessarily happen. Doesn't necessarily happen fast, right? This is where the feeling of like, if I just blame somebody else, like they're going to let me out of it. In fact, no, you'll probably get stuck in it for longer because you become a very useful witness for the plaintiff's attorney. And so there, that's a misconception. Like if I can just show that this is somebody else's fault, I'll get out of this. If I can, there is this misconception like in the deposition that like you can sort of talk your way out of it, or that if they hear your side of the story, that then they're going to drop you because then they know that you did everything right. That's not how this works at all. The plaintiff's attorney, there's no judge in the room, there's no judge in there. Like there's not like, I've had so many people think the judge would read the testimony and then be able to throw the thing out because it didn't seem, no, it does not work like that at all. There's, you do your depositions and basically each side is looking at the deposition as a tool, right? The deposition, your purpose there is not to like explain away stuff. You're basically being evaluated as a witness. Like, yes, they want to find out what happened. You're there under oath, but they also want to see, because they will likely videotape it, like, how does this person appear? Like, what do I do when I poke this doctor, 20 times in the same place? Like, can I get this doctor angry? Do they seem arrogant? Do they seem like this is largely about optics once it gets rolling, and whatever kind of story a plaintiff's attorney can make out of whatever evidence you give them, to get a jury to sort of believe something. So they're looking for a soundbite. They're looking for you to, to fall into various traps that they're very good at setting. Remember, they go to school for this. Like this is what they do, like day in and day out. Not that we can't learn it also, but we want so badly for this to be about our medicine. And I mean, sometimes it is when you got a slam dunk, on one side or the other, like this was clearly error. And you're like, this is a mistake. And then yes, you're going to have to own your lumps. And there's still a way to testify around that. But when you did everything right and they're still coming at you, that can make you feel really disheartened, unless you understand from day one that this is largely about plaintiff's attorneys drive this whole, it's an industry. It's a huge industry. Medical malpractice litigation is a ginormous industry. And now private equity has gotten involved, right? There are third-party litigation investors because this is big, big money these days. They don't invest in the defense, right? They only invest on the plaintiff side, right? So there's investors in it. This is about them recouping their investment. This is about money. This is about the plaintiff's attorney taking, usually 40 to 50% off the top, plus expenses, plus whatever they owe their investors. And the plaintiff themselves is going to get like some tiny percentage of whatever it is that they walk away with. And the best thing for a plaintiff's attorney is getting a big, fat, juicy settlement. That's what they want, right? And so the way that they have conspired, the plaintiff's bar is probably the most, perhaps, powerful lobby in the United States. There are plaintiff's attorneys stacking nearly every state legislature. This is about money, right? And we are these like tiny little cogs in the system, that keep our heads down and think that if we just do our medicine and just do it right, that somehow we'll be safe from this. But if you practice in any kind of field that has risk involved, at some point you're going to fall on the wrong side of risk, right? Someday it's, you'll flip that coin and it's going to come up tails. And that patient will have an outcome that you didn't want. And then potentially there will be a lawsuit and you will be deer in the headlights, not understanding that everything that happens from there on is about whether or not the plaintiff's attorney wins and takes home a big chunk of money. And they are highly motivated to do so. So yeah, the biggest misconception is that once you're in it, this is about your care. It's not. It's about a story that they can fabricate. I mean, they changed in my 2 trials, they changed their theory of negligence like so far, right? In the first trial, they couldn't make it stick. They couldn't make it work. It was not true. And we were able to prove it. So then they came back a second time and completely changed what they thought the whole theory of negligence, all the things they thought I should have done, right? Got a new expert, and it was a lot of crap, right? This is nonsense. But if you take that to heart and make this about you and your care and you as a human being, this thing will eat you alive, which it did. for me for many, many, many years. And so you have to understand not just like, yes, this happened. I have to contend with the human side of the events, my love for the patient, my love for my, medicine, like the fact that I really want the best outcome for my patients all the time. And then it's not always possible. And you've got to deal with that. But this over here, civil litigation is not about your medicine. It's a dispute resolution mechanism. That's all it is. This is, should we pay some money for this? It's not set up to judge your medicine. It's lay people looking at something. It's not set up for that. So we need to find better systems that are actually a fair adjudication of care before you can make this about your medicine.
I pause here for this week, but don't go too far. We'll be back for part 2 next week, and we'll tune into the rest of the conversation. Thank you.